Hello, everyone. Welcome to another session of ILA Dialogues. Today, we have with us Solicitor Amrita Kharkar. Amrita is the co-founder and partner of the law firm KV Legal. She is a practicing solicitor in the field of real estate and insolvency law. She graduated in law from Pune University, and thereafter she qualified as a solicitor and became a member of the Bombay Incorporated Law Society. Her determination and vast experience in the field of law and her passion to work in the legal field has resulted in establishing her own law firm. Her expertise in drafting and vetting of agreements and success in several matters before various courts is being rewarded by way of satisfied clientele. Welcome, Amrita. We are really glad to have you speak to us today. Today, Amrita will be speaking about the recent amendments to the Insolvency Bankruptcy Code and its SWOT analysis. Welcome, and over to you, Amrita.
Thank you, Sirisha. It's a pleasure to be invited here. I would also like to take an opportunity to thank Jamshed sir for having me here on this dialogue. In fact, it's his ILA formation which has really got all the lawyers together, not just in India, but internationally as well. So we definitely stand to gain by his work that he has done. I would also like to thank Sirisha for really coordinating well for this particular dialogue series. They're really going to be very efficient for people to come across and know more about various topics. So so today's topic I have chosen, I would like to talk about topic by way of a slideshow. So Disha, I could do a share screen for this particular.
I have enabled it. Can you try once?
I'll try it.
Yeah.
It says that the host disabled the participant screen sharing.
Now?
Yes, I can. Yeah. So this topic is all about the recent amendments in wake of COVID-19 to the Insolvency and Bankruptcy Code, and we'll be doing a SWOT analysis of these amendments. Now, the reason I've chosen this particular topic is for the very purpose that the entire Insolvency Code has been altered because of our COVID-19 pandemic, which is like the unprecedented times we all are facing today. But the changes that have brought about are going to impact the economy, which stands to be crippled today because of the impact of the lockdowns that have been declared by the government. This is a scenario which is not just in India, but we are facing it internationally also. Therefore, it is very important to understand what these amendments are going to do to the insolvency law. So I'll take you through the various amendments, and I'll be discussing only the primary amendments which really need a judicial intervention in these topics. So first, there were 4 major amendments that have come across. I would say that they are amendments, they are in form of notifications, they are in form of certain kind of orders of the Supreme Court or the NCLAT. So let's take each amendment one at a time. The first amendment is a minimum default has been increased from rupees 1 crore to 1 lakh of rupees. So let's go to the first amendment. The central government has, by notification on the 24th of March 2020, come up with a notification to 1 lakh rupees. This notification has come pursuant to the powers conferred on the central government by way of Section 4. Now, I would like to mention here that this particular notification, which has come on 24th of March, is not only because of the COVID-19 impact. In fact, the government was trying to bring in this particular notification even prior to the COVID-19. But COVID-19 just became a trigger point to get this notification out. Now, why was the government trying to get this notification in place? The reason was that Now, insolvency code is basically the very object of the code is the revival of the company, the resolution of the company. It cannot be used as a recovery tool. Now, we have seen a lot of NCLT filings which are happening, but they were basically in the form of more of a recovery structure. Now, NCLT were not framed, or the code was not framed for the recovery. The code was framed for the very revival, resolution, or increasing the entrepreneurship. This definitely was the object, which has been highlighted in plethora of cases, which said even the Swiss ribbon case, which has recently come, which discussed these particular objects. And therefore the government felt the need to enhance the default limit from 1 crore, default limit from 1 lakh to 1 crore. Now, what is important here to understand is that whether this particular notification is prospective in effect or retrospective in effect. Now, this is very important because the notification is very silent as to whether it will have a retrospective effect or a prospective effect. Now, the cardinal rule which the interpretation of statute says that any statute or any amendment which is brought in, if it is going to affect the rights of the parties, is basically a prospective in nature and not retrospective. But however, this notification remains very silent because the court may interpret it as a technical limit increase, or it may say that it has the power to affect the rights of the parties and therefore it should only be prospective in nature. So with this particular point in view, whether it is prospective or retrospective, I will take you to the next slide saying the applicability of the trigger point where the prospective and the retrospective effect can be well understood. Now, the existing cases which are before the NCLT, I've categorized it into three parts. You have the admitted petitions, you have the petitions which filed but are yet pending the admissions, and then you have the demand notices which are there but the petitions have not been filed. What happens to these cases? So will this particular notification have any effect on these particular existing cases? Now let's take each point. First, the admitted petitions. Now definitely the admitted petitions are the ones which are admitted and therefore the CIRP process will continue and the notification will have no effect on the admitted petition. But now the file petitions pending admissions, here is where we will require the judicial intervention because the file petitions are just pending admission. So they may not be at the threshold of 1 crore. They might be lesser than 1 crore, maybe the 16 lakhs, 20 lakhs of any value. And therefore, what is the fate of these filed petitions pending admission? So there could be, so these are basically untested waters. So what the NCLT could do, or maybe the threshold limits, the NCLT can ask them to match the threshold limit. But then matching of threshold limits can only be done in case of financial creditors, as the code permits financial creditors to file the petition in aggregate. Therefore, many financial creditors can come together and file it in aggregate and make the threshold to 1 crore. But then such leeway is not available to the operational creditors, and therefore operational creditors will not be able to match the threshold limit if tomorrow NCLT says that threshold limits have to be matched. Now, the reason why I'm saying so that the threshold limit should match and that NCLT might come up with such an option is that, as we all are aware, that the home cases which are still pending in the Supreme Court, and the Supreme Court has issued a status quo order in that. Now, what had happened in that particular issue was that there was an amendment which was brought in which said that either 100 or 10% of the total number of home buyers could trigger the insolvency. Now, if that was the case of triggering the insolvency, the court said that the pending petition should match this threshold, and therefore they went to the Supreme Court and the order is still pending. So if the courts are saying that the threshold limit should be matched, then it could be a scenario that file petitions pending admission can face such a scenario, or we would require a clarification or a judicial intervention on this particular admission. The third point is the demand notice, where demand notices have been issued but the petition is not filed. Now, mind it here that when we say that if this amendment or this notification is given a retrospective effect, then it would affect the rights of the parties because demand notice is an integral part of file petition. petition under Section 9. So if no demand notice has been issued, petition cannot be filed under Section 9 of the code for the operational creditors. And therefore, if demand notices have been issued and petitions not filed, then the court would definitely not permit if the threshold limit of 1 crore has not been satisfied. So again, the rights of the parties will be affected if this particular amendment has been given a retrospective effect. So moving on to our next slide, understanding whether it is prospective or retrospective in nature, we also need to understand whether this notification has any impact. So whether they are positive in nature or they are negative in nature. Now this is a primary relief for the MSMEs, small companies, because no insolvency petitions will be filed because their defaults might be smaller in number. Therefore, the insolvency process will not be triggered. So definitely this will help in improving our economy, which is currently crippled. It will also help many entities and give certain time to the entities to come back and make the default ratio, which has gone down, to a their businesses. Then we have another impact of this notification is that there would be a shift of burden from corporate debtor to personal guarantors. Now this concept of personal guarantors, these sections for personal guarantors have been recently notified in December 2019, and therefore they're already in the untested waters. But what has happened is that if you cannot file a petition against the corporate debtor because of the notification, you can definitely file it against the personal guarantors. Why? Because the 1,000. So if you cannot proceed against the corporate debtor, you can definitely proceed against the personal guarantors. And there is also no suspension of the section 9, 7 and 10, which I'll be discussing later, to the personal guarantors. And therefore, personal guarantors are going to be in a problem in the event if no amendment or a notification is brought in view of the personal guarantors. Then we come to the third point, is the creditors. So definitely financial creditors, if there is an aggregation of financial creditors, they are going to stand to benefit, because the code is very clear that if there is a creditor who has got a debt of 10 lakhs and there is one creditor with a debt of 90 lakhs, the two can come together and match the threshold of 1 crore and file a insolvency petition against a corporate debtor. But then what about the operational creditors? There is no such provision for the purpose of there is no such provision for the operational creditors, and therefore it is essential that the operational creditors need to have a threshold limit of 1 crore to proceed further. Understanding these, another point that I would like to mention is that this particular notification is a delegated notification. It is not an amendment to the insolvency code, and therefore this will also have to be checked to understand whether this particular notification should be given a retrospective effect or a prospective effect, knowing the way that it is just a notification which has brought in the change and not in form of an amendment to the IBC. However, being a notification, it is a power which has been drawn from the code itself, and therefore it will definitely have its applicability, but the water needs to be tested in terms of being a retrospective or a prospective one. We now move to the next point in this same notification, which is trigger point for IBC financial creditors. Now, when I say the trigger point is that I've set out a few illustrations here. Now, what illustrations? It will just help you to understand that whether a default of 1 crore and above or financial creditors having defaults of lesser value, how they can approach. I've kind of covered these illustrations now itself, that where I've mentioned that if there is a straightaway default of 1 crore and above, you can definitely file your petition. Suppose there is a default of 5 crores by one financial creditor, and there's one more financial creditor having a default of 10 lakhs. Then can a creditor having a default of 10 lakhs file the petition? Then the answer is yes, because he can aggregate it with the other financial creditor and file the claim. You have the third illustration. Suppose you have a financial creditor and you have an operational creditor. However, the operational creditor's debt owed is only 60 lakhs. The operational creditor definitely cannot go because his threshold limit of 1 crore is not satisfied. But can the operational creditor aggregate it with the financial creditor? The answer is no. The financial creditors have to be together, and the operational creditor cannot join hands with the financial creditors. Moving on to the next slide, this is the case of operational creditors. So if we have operational creditors to the tune of 30 lakhs, then we have some operational creditors to the tune of 2 crores and another with 75 lakhs. What happens in these circumstances? It is clear that aggregation is not allowed, and therefore everyone will have to individually file. And if they individually file, they'll have to satisfy the threshold of rupees 1 crore. Moving on to my next section, section 7. Important amendments which were brought about in the IBC. This is an actual amendment to the IBC proceedings. The ordinance of 5th June 2020 has introduced a section 10A to the code. Now, what is a section 10A? It has restricted the filing of any application for initiation of the CIRP of a corporate debtor for any default arising after 25th of March 2020 for a period of 6 months or such further period not exceeding 1 year from 25th of March 2020. And this is very important to be noted here is the specified period. Now, what we have seen here is that no application can be filed. So there has been a total suspension of section 7, 9 and 10. 7 is for financial creditors, 9 is for operational creditors, and 10 is for the voluntary insolvency. So further to this particular section 10A, there is a proviso which has been added. Now, mind me, this proviso is very important to understand that it gives a very blanket provision that no application shall ever be filed for initiation of the CIRP of a corporate debtor for the said default occurring during the specified period. Now, nowhere in the history has such kind of a provision come into place where they have given a blanket exclusion of this specified period. So, suppose there is a default in this specified period, there can be no investigations or initiation of a CIRP in this particular period. However, can there be any investigation post the CIRP process? That of course also cannot happen because no application shall ever be filed for initiation of a CIRP of a corporate debtor for the said default occurring during the specified period. Now, the CIRP can never be initiated on the basis of the default during the specified period, even if the default is continuing after having occurred during the specified period. Now, what is important in this particular suspension is that if the proceedings are suspended, then what happens to the default? What happens to the default is that certain other avenues open up. What are the certain other avenues? Companies can go for a restructuring regime, which has already been notified by the RBI in 2019. However, this restructuring regime is available only for the registered creditors with the RBI. But then we have the DRT. Of course, we are aware of the Supreme Court orders and the petitions filed in the Supreme Court to strengthen the DRT process. So the DRT mechanism might just improve or improvise because there is a suspension and insolvency cannot be invoked during this period. Or what we can have is the mediation which can come into place. There can be one-time settlements with these financial creditors or operational creditors. We could have the civil applications increase, that is the summary proceedings for money suits coming into being again. So many other forums will again come into being for this particular period, that is a suspension from 7, 9 and 10. Therefore, it is very important to understand that this suspension of section 7, 9 and 10, whether it is positive or negative. Now, knowing that it is a positive factor, why? Because it will definitely help the MSMEs to come back on their feet, because the lockdown has definitely crippled the economy, and therefore it is essential that some breather should be given to the companies, some breather should be given to the MSMEs so that they can stand back and continue their business. Because like I said, the object of the code is the revival and the resolution, and not to send the companies into liquidation. And therefore suspension of section 7, 9 and 10 was felt essential and has been come into place. But whether this particular blanket provision is important or necessary is something which really needs a judicial intervention, because it is very difficult to understand that a wrongful transaction, if it has happened, or a fraudulent transaction, if it has happened during this particular specified period, the directors of the company will definitely escape all the hardships that they would have otherwise had to go through if it had come to light, or this there was no such default period excluded from the CIRP process. And therefore it is very essential for us to understand that there are going to be the pros, there are going to be cons for suspension of section 7, 9 and 10. We then move on to another important amendment to the code which was brought about by the same ordinance, and that was to section 66(2), which dealt with the fraudulent trading or wrongful trading. And it is a non-obstantate clause has been inserted into section 66 of the IBC to give protection to the directors of the corporator. Accordingly, no application can be filed by a resolution professional under section 62, 66 in respect of such default against which CIRP is suspended under section 10A of the IBC. Therefore, this again gives a protection to the directors. But then again, whether a fraudulent trading or a wrongful trading can happen, yes, it can. There can be a misuse, and all this have to be definitely construed accordingly to understand the impact of the ordinance. But at the same time, ordinance was essential because our economy has definitely crippled because of the lockdowns. We do not know how long the pandemic is here to stay, but definitely economy needs to grow and certain amendments need to be brought about, and therefore we have these ordinances. Understanding that these ordinances have come into place, we also have certain petitions which have been filed in Madhya Pradesh High Court which have challenged these ordinance, saying that these are against Article 14 and 21, violating the fundamental rights. They need to be tested. Such kind of blanket provisions cannot be given because it is a misuse and abuse of the power. Therefore, and this particular Madhya Pradesh decision is still pending because the state is yet to respond to the High Court, and they have been given time of 6 weeks, and definitely the hearing is somewhere in August. So we have to wait and observe what actually is going to be the fate. If you go to see in the current scenario, this particular amendment has definitely helped certain sectors of our economy, but at the same time, whether this particular sector is going to get benefit for a long term or a short term is definitely to be tried with time. We now move on to our next slide, which is relaxation in timelines. Now, what are these relaxations in timelines? To understand these relaxations in timelines, we need to understand when did they come into being and why were they felt. As soon as the lockdowns were declared, two things that happened. One is the IBBI, that is the Insolvency and Bankruptcy Board of India, by a notification on 29th March 2020, has amended the insolvency resolution process for corporate persons regulation 2016. They have included 40C regulation, which has increased the timelines. Now, what did it do? It excluded the timeline for any activity that could not be completed due to such lockdown. Further, the enclave suo motu took this up and has given a limitation saying that it will exclude the time for the purpose of litigation from the entire CIRP process. The Supreme Court has also suo motu on 23rd of March 2020 by an order increased the limitation and has said that the period of lockdown shall be excluded from all the proceedings. And therefore, these relaxation and timelines were very essential because know that CIRP is a very time-bound process. It is a 330-day process, and therefore these timelines have to be strictly followed. And therefore, we felt the need that IBBI notification came into place. The NCLAT order is there. We have the Supreme Court order also, which increases the timelines. But however, the Supreme Court order will be applicable only to the proceedings which are before the various courts and tribunals. It will not increase the timelines as far as the CIRP timelines are considered. But then the IBBI notification is in place, which says that the regulation timeline shall stand increased in the case there is a lockdown, and that period shall stand excluded. However, if you note that under the IBBI notification, 29th March 2020 has been notified as the date from which the exclusion will start. Now, the lockdowns began from 24th of March 2020. Now, this 3-day period has been excluded or has been purposely excluded from the exclusion of timelines is yet to be considered, or there has to be some notification or a clarification which we shall be awaiting from the IBBI. There is no intelligible differential per se that we can find out why these 3 days have not been considered for the exclusion for the purpose of the lockdowns. With this, I will conclude the screen sharing, and I would like to say that the entire insolvency code has been amended only with the perspective that this particular amendments will help improve our economy. The notifications will bounce back our economy, but at the same time, it will have its own issues. It will have to have some judicial interventions that I've already explained. So it is essential that these notifications, these amendments are really studied in the light of the given scenario only, because the way they have been drafted, it definitely brings in a lot of loopholes which have to be filled in either by way of certain clarifications or notifications which we should all await. That would be all about my impact on the insolvency code due to the COVID-19 and the amendments that have been brought about. I would now give it back to Sadisha, if Sadisha is here.
Hi. Would anybody want to ask any questions to Amrita?
Shit here. Hello, can you hear?
Yes, sir, we can hear you.
Yeah. So my question to you is that as you said, it would require judicial intervention, but do you think that there would be a large number of persons, corporates, and others who would actually be sort of falling within the parameters and the changes that and do you think that there would be a spike in, not in COVID cases, but in insolvency sort of related litigation?
See, there would be a spike if these amendments would not have come into being. So definitely, like I said, that there are the pros for this particular amendments that have come in. But then the way I would say that the way they have been drafted, perspective or because it does in nature, then will that affect the whatever the pending cases that are there but not admitted? Because the code itself is very strict about its object, it's very strict about its timeline. Taken into consideration the various objects that were circulating around it. So I believe that if these clarifications would have come in, it would have been more easier. Or if you say that the suspension, that is a 7, 9, and 10, of course, it will help the entities and it will lower litigation in NCLT. But what would happen is that, what if there is some fraudulent transaction during this default period? There is no inquiry that can be then set up to identify about the fraudulent transaction. And therefore, it would be essentially, instead of giving a blanket provision, there could have been certain provisos drafted in such a way that, that kind of issues would have been taken care of.
Thank you.
Does anybody have any other? Then we can wind it up.
So, okay, so I'll definitely reach out to our response.
Okay, thank you, Amrita. That was really, really insightful. Thank you for taking out the time and speaking with us. Really looking forward to our next session. And if you would want to contribute anything, in the coming months, do let us know. We'll be really glad to host you.
Sure.
Thank you.
Yes. Thank you so much.